All right, guys, I do got a quick editorial for you here. Before I get to that, I want you guys to do a video, if you will, of your favorite Arnold Schwarzenegger saying. I got like a bunch. I mean, I won't do the old get to the chopper, but I like, it's not a tumor, or get down, get down. And he always goes, you notice that? Okay. Anyway, that came about because we were inside at work talking about Arnold Schwarzenegger. And I guess he pranked somebody. He wore a big mustache and a wig. And he was going to prank these people coming to buy cars at a car lot. It was going to be an Arnold Schwarzenegger prank. So he comes out, so you want to buy a car? Hey, come, let me show you the cars. I'm like, that's Arnold Schwarzenegger with a mustache and a wig. So it went over like a lead balloon. Anyway, I'm going to get to this. The Supreme Court has ruled against the Fourth Amendment, at least I think so. And they're using exigent circumstances as a reason for this ruling. So the Supreme Court has written, this comes from NPR. Okay, thank you to NPR for this story. I will put a link to it in the description box below. The Supreme Court has ruled that police may, without a warrant, order blood drawn from an unconscious person suspected of driving under the influence of alcohol. I wonder if that includes prescription medicines and all that as well, if they're unconscious. The Fourth Amendment, excuse me, I'm sorry. The Fourth Amendment generally requires police to obtain a warrant for a blood draw. And remember the nurse who got arrested and all that for interfering and because she wouldn't allow it? I guess the Supreme Court's changing that. The Fourth Amendment generally requires police to obtain a warrant for blood draw. But on Thursday, which was today, the court by a 5-4 vote upheld a Wisconsin law that says people driving on a public road have impliedly consented to having their blood drawn if police suspect them of driving under the influence. It also said that exigent circumstances permit police to obtain a blood sample without a warrant. Now, is that, I don't know, is that in an accident or if they're just driving or what have you? Because they may pass out on the way to jail. I don't know. Moving on. A lot of times, though, it's a car accident, and they're unconscious at the accident. Justices Samuel Alito, Clarence Thomas, Stephen Breyer, and Brett Kavanaugh joined the Chief Justice John Roberts in the majority vote. I'll read those names again. Justices Samuel Alito, Clarence Thomas, Stephen Breyer, Brett Kavanaugh, John Roberts, who's the Chief Justice, in the majority vote, 5-4. Was that 5? 1, 2, 3, 4, 5. Okay, so who's the one who went against? I don't know. The decision conflicts with previous court rulings in which the justices ruled that a blood draw is a significant bodily intrusion into a person's privacy. Yes, securing your persons and property. And that there are less intrusive ways of enforcing drunk driving laws against unconscious motorists. Getting a warrant, for instance, which in these tech-savvy days can be done relatively quickly and easily. Now, in 2013, for instance, the High Court ruled that police violated the Constitution when they ordered a non-consensual blood draw without a warrant in a routine Dewey case, DUI. The vote then was 5-4, but two of the justices in the majority, Antonin Scalia and Anthony Kennedy, are no longer on the court. The constitutional rights case produced 4 opinions, 2 concurring and 2 in dissent. 28 states have similar laws to Wisconsin's. The case Mitchell versus Wisconsin was accepted by the court at the start of this year, and amid sharp divisions among state appellate courts over whether the blood draws violate motorists' Fourth Amendment rights, the case was argued in April. Well, it kind of does. I mean, you have the right to be secure in your property and persons. Persons and property, right? The court's ruling came in the case of Gerald Mitchell, who was found by police near his van along the shore of Lake Michigan. One of Mitchell's neighbors had called police to report that he was drunk and suicidal and that he watched him get into his van and drive away. After police found him walking near the lake, they administered a breath test and then drove him to a hospital for a blood draw. Mitchell passed out in the car, and by the time the group arrived at the hospital, he was unresponsive. At that point, police ordered hospital personnel to administer a blood draw. Based on the results of that test, Mitchell was charged and convicted of driving while intoxicated. When he lost in Wisconsin state courts, Mitchell appealed to the Supreme Court, contending that the blood draw violated his constitutional right to be secure in his person unless his intrusion is authorized by a warrant. So I read that kind of fast, but you can go back and read it below if you want to just read it and go through it. Basically, the sum of this is that the Supreme Court has now said under exigent circumstances, the police can go in and draw your blood if you're unconscious without your consent. They can just do it and say, gotcha. Now I'm wondering, can they do this at any time? So how far is this going to be taken? How far are they going to move this envelope or push this line? You're sober, you get in a car accident, you're unconscious, they go, let's just draw his blood and find out. You know, I mean, how far is this going to go? Are they going to start drawing the blood of every unconscious motor vehicle person to see if they've been drinking? It's just, this opens up a whole can of worms. I mean, it just throws the Fourth Amendment right out the window. And how far can this go? Under exigent circumstances, can they now just stop people on the street and start? Well, they already do that, right? Well, you match the description of a guy across the town that robbed the bank. And then they find out you're not the guy. They don't apologize. They say, all right, see ya. And they get in their car and drive off. So, I don't know. It's our courts today and our law enforcement officers, not every one of them, but we're talking specific ones that are guilty of this. If, you throw a rock into a pack of dogs, the one that gets hit yelps the loudest. There you go. So, but you got law enforcement officers out there in the courts that are just pushing the Constitution away. I don't know what's going on, guys. I want to hear from you guys in the comment section below what you think about this. Again, to sum it up, the Supreme Court has ruled that now under exigent circumstances, the police can draw your blood without a warrant and without your consent. They can just do it if they suspect you of DUI. Now, what does that mean? Suspect you of DUI. How do they get that suspicion? Probable cause. Well, he was in an accident. He ran a red light. He must have been drunk. News Now Ukaipa, letting you know what's going on across your nation.